What's up, everybody? Merissa v. Grayson here. For those of you who don't know me, I'm Merissa v. Grayson. I'm a child custody and family law attorney, mediator, and co-parent coach, and you are watching Merissa v. TV, where we talk about all things blended family and occasionally stray to other things I might just feel like talking about for the day. And today, I just want to talk about representing yourself in court, because I see so many people make mistakes over and over that can be avoided because they're representing themselves and not taking it as seriously as they should. So the number one rule is, if you're going to represent yourself, you got to represent yourself. You got to represent, right? So there's no half-stepping. And if you half-step, you're probably going to run into some kind of trouble when it comes to your case. So if you're going to represent yourself, you need to represent yourself to the best of your ability, the same way you would expect a lawyer to, which means you're going to have to invest some time, you might have to invest some money, and you might have to invest a lot of energy into making sure that you know the things that you need to know and you're prepared to represent yourself. So, for example, I was in court the other day and there was this jurisdiction issue. There was a dad who had filed for custody and in California, and a mom had filed for custody somewhere else after dad filed. So dad filed, he served mom with his case. Mom then files somewhere else after she had essentially kidnapped the kid and kept the kid away from the dad for like 3 months, and she still hadn't served him. What happened was, because the dad did not know the laws related to jurisdiction, the court, for some reason, and I still haven't figured out why, the court made the decision to transfer the case that was already active in California to the other state, mainly because the mom made a better argument. And my issue was that based on the facts that were presented in court, if that were my client, that would not have happened, because legally, based on the rules and the laws in California, or the jurisdiction laws, the judge didn't have any authority to make that order. But because of the fact that this guy was representing himself and did not know that she didn't have the legal authority to make that order, because let's keep it all the way real, judges don't know all the laws. I'd say probably about 60% of the time, I may have to educate the judge on what a particular family law is, because they don't memorize all the laws. It's impossible. So when you're presenting your case, you have to know the laws that support your argument. And because he did not know that, his case was shifted to out of state, and that also caused a delay in his ability to see his kids. So he's like, well, what am I supposed to do in the meantime? Am I not going to see my kid for 3 months while we're getting the case transferred? And the judge was like, I don't know what to tell you. Yeah, I'm moving it. And had he known and had the legal authority to cite to the judge and say, no, Your Honor, you can't make this ruling. The law says X, Y, Z, and these are the facts that apply. You can't make the ruling. The judge more than likely would have changed their mind. Like, it literally made me cringe to watch him go through this by himself. So anyways, my point is that if you're going to represent yourself, there ain't no half-stepping. You got to go all in if you want to be successful. And I totally get that sometimes you may not want to hire a lawyer. You may not be able to afford to hire a lawyer. I totally get it. So if you're in that situation, then you got to represent yourself. No half-stepping. So I'm going to just give you 4 quick tips. Number 1, make sure you know your procedure. Till this day, I still catch other attorneys who aren't familiar with procedure and haven't studied procedure, and it messes up their cases because I know procedure very well. I study it very hard. So you're going to need to look up the rules of civil procedure and the family law rules related to procedure in your area so that you're familiar and you know exactly how things are supposed to happen in your case. The next thing you need to know are the laws that are related to your case. So if you are dealing with a divorce case, then you need to know what the divorce laws are. What are the laws related to property division, spousal support? Can he just kick you out the house? Can she just require you to, pay the car note after you guys have separated? Like, what are the laws that apply to your case? If you're in a criminal case, which I would not advise you represent yourself in a criminal case, but if you are, you need to know the criminal laws that apply, the criminal rules of procedure. All of these things matter. Additionally, take some time out once you know who is assigned to hear your case, which judge is assigned. Take some time. Go sit in their courtroom. Watch their demeanor, listen to their cases, see how they respond to people who aren't represented versus people who do have lawyers. Watch and see what irritates them. What kind of rulings are they making? What kind of arguments are they accepting? Do they seem to know the law, or are the attorneys educating them on the law? Pay attention to these things. The more you know about a judge and the more you've observed them, the easier it is to make an argument for your case in front of them, because you've studied, the way that they handle their cases. All judges are not created equally. I still to this day will go and sit in the courtroom if I know that I'm going in front of a judge that I am not familiar with, because I don't like to lose and I don't like to be embarrassed. And I like to know what's going on, so I don't want to be blindsided. So I go and sit for an hour and just listen and watch and observe. I observe everybody, the clerks, the judges, the bailiff. How does everybody interact? How does the courtroom function? All of that stuff matters. And last but not least, be prepared. Have all the documents you need. Have copies of your proof of service. Make sure that if you're trying to introduce evidence, you know what the rules are related to the evidence, and you know how many copies you're supposed to present. All of this stuff matters. Courts don't care if you didn't know. I didn't know I was supposed to file this is not an excuse. I didn't know that I had to serve them. I didn't know that the person that served them had to be over 18. I didn't know I couldn't just deliver the documents to them by email and that wouldn't count. All of this stuff is important. Even though it may seem like a little small detail, it matters, and it could easily cause your case to be delayed if you don't know this stuff. So anyways, that's just my not so legal advice. I'm just tired of seeing people try to represent themselves and half-stepping and messing up their cases that they actually could have won. Oh, and last but not least, at minimum, if you do nothing else, try to consult with a lawyer. Yes, you may have to pay for a consultation. A good consultation is going to cost you if you want to be able to get information that's going to be helpful for you. But I've literally sat down with someone for an hour, walked them through how to conduct their trial, how to examine their witnesses, how to catch witnesses in lies, and all of that stuff, how to present their evidence, and they've actually won. So at minimum, if you can't afford or just don't want to hire a lawyer to represent you, sit down, get consultation from a diligent and competent attorney, and, go all in. So if you're going to represent yourself and do it well. All right, until next time, I'm Merissa V. Grayson. Catch me on Instagram, Merissa V. Grayson. That's Merissa V as in Victor Grayson. And I'm also on Facebook and YouTube. Until next time.